നീരജ് കേൾക്കാൻ പറ്റുന്നുണ്ടോ നീരജ്? ഓൾറൈറ്റ് ഓൾറൈറ്റ്. സ്ക്രീനിങ് പ്രോഗ്രസ്സിലല്ലേ? നീരജ് കേൾക്കാൻ പറ്റുന്നുണ്ടോ നീരജ്? ഓക്കെ ശരി ശരി ഓക്കെ. സ്ക്രീനിങ് പ്രോഗ്രസ്സിലല്ലേ? ഓക്കെ ശരി ശരി ഓക്കെ. യെസ് യെസ് യെസ്. ജീന മാഡം അല്ലേ? യാ കേൾക്കാം 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 മാഡം. ക്ലിയർ അല്ലേ? ഞാൻ പറയുന്നത് ക്ലിയർ അല്ലേ? ഓക്കെ മാം ഓക്കെ ഓക്കെ. യാ കേൾക്കാം 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 മാഡം. ക്ലിയർ അല്ലേ? ഞാൻ പറയുന്നത് ക്ലിയർ അല്ലേ? ഓക്കെ ഓക്കെ. Hello, Sophie ma'am. Hello. Hello, Sophie ma'am. Hello. Sophie ma'am, can you listen to me? Hello, Sophie ma'am. Hello. Sophie ma'am, can you listen to me? Gina ma'am, can you listen to Sophie ma'am's voice?
No, sir, I can't hear.
Sophie ma'am, your voice is not clear, ma'am. Gina ma'am, can you listen to Sophie ma'am's voice?
I have.
Yes, ma'am. Yes, ma'am. Now it's clear. Now it's clear. Ma'am, we again lost the voice, ma'am. Yes, ma'am. Yes, ma'am. Now it's clear. Now it's clear.
Just checking my earphone again.
Ma'am, we again lost.
How's it now?
Yeah, now it's clear, ma'am. I think that the 3.5 jack is somewhat loose or something.
Earphone again.
Ma'am, we again lost.
How's it now?
Yeah, now Gina ma'am, are you able to listen to ma'am's voice? 3.5 jack is
No,
now it's clear, right?
sir.
Loose or something.
Earphone again.
Now it's okay. Yeah, now it's
How's it now?
Yeah, now Gina ma'am, are you able to listen to ma'am's voice? 3.5 jack is now it's clear, right?
now it's okay. Yeah, now it's
So first of all, I would like to welcome our principal, Dr. Rani George ma'am, for she is presiding today's function. So she is the backbone of our college. Really, she is an inspiring one, and she always encourages us to conduct such kind of different activities and webinars in our college. Welcome you, ma'am, in this webinar. Welcome you, ma'am. Next, I would like to welcome. Yeah, next I would like to welcome our chief guest, today's chief guest, Dr. Sophia. She is Assistant Professor of Law, National Law University, Delhi. She is postdoctorate in Law of Social Reproduction. Her subject area is legal anthropology, labor rights, informal economy and globalization, human rights, IQAC. She has both national and international publications. Recently, ma'am has published a book. The name of the book is Customary Rights of Farmer in Neoliberal India. Despite the busy schedule, she took the time and she accepted our invitation to take this webinar and provide her valuable knowledge and wisdom to the students. So, welcome you, ma'am, on behalf of CS Institute of Legal Studies. Welcome you, ma'am, to this webinar.
Thank
Next,
you
I would
very
like
much. Thank you very much, Gina, for the. Oh, okay, it's continue. Okay.
Last but not the least, I would like to welcome all the teaching staff, and all the students who are participating in this webinar. So really, it will be very helpful to you all. So welcome you once again. Welcome you all. Thank you. So next, I would like to invite our principal, ma'am, Dr. Rani George, for the inauguration. Ma'am, Rani, ma'am.
Thank you, Gina. Thank you, Gina. And thank you, Sophie, ma'am. So, our topic is labor reforms, industrial relations, and labor rights. And as we all know, there's a new law in this regard. And we are also aware of the 4 codes in this area, that is wage code, social security code, occupational safety, health and working condition code, and industrial relation code. And we know in a developing country like India, labor law plays an important role, and the relation between employer and employee, they are to be regulated. These laborers, they should have a say in the decision making. And we know the importance of the relationship and the role of state in this area. So I hope students will make benefit of this session. Our speaker will enlighten on this area with regard to the industrial relations and labor rights. And with these words, I inaugurate this session. Thank you.
Yeah, thank you, ma'am. Yeah, yeah. So next, I would like to invite our Sophia ma'am. So today's resource person. So ma'am, all the stage for you. Welcome you, ma'am.
Thank you very much, Gina. Thank you, Dr. Rani George and Harris, for inviting me to give this lecture. May I take the liberty of asking Ashik to mute your mic, please?
Ashik.
Ashik, can you mute your mic, please?
Ashik.
Or can the coordinator mute his mic?
Yes, ma'am. Yes, ma'am. I'm trying to mute his mic.
Yeah.
Yes, ma'am. Yes, ma'am. I'm trying to mute his mic. Yes, ma'am.
Okay, thank you very much. So as Dr. Rani George mentioned, today I thought we will discuss on new labor reforms. And not that I'm going to deal with the entire labor reforms, but we are going to look at the context in which the labor reforms were introduced in India in 2020. Though the process started from 2015 onwards. If we remember the history of new labor reforms in India, the code started, the new draft code started coming from the ministry from 2015 onwards. So today we are going to discuss the context of labor reforms, and in particularly one code in detail, that is the code on industrial relations. The code on industrial relations, there were many drafts that came in from 2015 onwards, and it was recently enacted in 2020. So we are in depth going to look at the code on industrial relations and its impact on labor rights generally, and specifically looking at the provisions. I took this topic because it's very important to start an educative process on how labor reforms has been transformed to deal with economic challenges of the time. And while doing this discussion, our main endeavor is also look at whether in the process of new lawmaking, the social justice framework that our constitution upholds and the statutory regime on labor relations has upheld has kept intact by ensuring decent work with dignity for the workers of our country. To look at, I will share to get into more details, it may be useful if I share my PPT with you. So please follow the screen. To look at, I will share to get into more details. Can you see my screen now? If I share my PPT with you, so please follow the screen. Can you see my screen?
Yes, ma'am. Yes, ma'am. We can see it. We can see it.
Okay. So first and foremost, as I mentioned, since we believe in our constitution, believe in social justice framework,
Yes, ma'am.
whether our labor reforms, the new labor reforms suit to the framework of social justice enunciated under the constitution and statutory regime that exists in the country. It's not that labor reforms is a very new concept. The concept of labor reforms has been long dealt with by labor jurists and labor theoreticians historically. So to understand the philosophy, it may be worthwhile to look at how Sidney and Beatrice Webbs and John Commons, these jurists, labor jurists, have written about the concept of labor reforms. So for them, the labor reforms generally intend to raise the condition of the working people, reduce class conflict, and make the world of work more efficient, equitable, and democratic. So their thrust was on improving the conditions of working force to able to contribute meaningfully to the economy and the nation development. Sidney and Beatrice Webb, known as the Webbs in labor theory, they put forth a two-pronged labor policy program to promote social and economic efficiency. The first prong is to improve wages, conditions, and treatment for workers in the lower part of the industrial pyramid. By doing so, it basically aims at productivity-linked wage. That means the wage grows along with productivity growth, which helps actually to maintain the macroeconomic demand-supply balance and social justice. Generally, in American jurisprudence, we see that American writers refer to this as raising the plane of competition. And the second prong, so the first prong is all about increasing the wages and accordingly increasing the treatment of workers in the shop floor. The second approach, the second prong in labor policy is more particular, looking at how how the workers require better working conditions, better standard of terms of employment and conditions at work. So one is to look at increase in wages. The first approach in labor reforms initiated by Sydney and Beatrice Webb is to look at how productivity linked wage would improve the conditions of workers and the economic efficiency in their lives. Second prong approach to look at how to regulate the standard of employment, terms of employment and conditions of work. So it's this holistic notion of development of labor. That is what actually been described as labor reform. So any change in labor law, any change in labor policy should be to elevate the status of the worker in this double prong approach. And when we look at our labor law paradigm or Indian labor law paradigm, it's very rich. Our labor law approach or perspective, labor jurisprudence is very rich. There are many classical cases from judiciary which sort of enlarged or widened the scope of labor rights in India. We do have a very strong constitutional basis for labor rights. We all know about the constitutional provisions. I'm not getting into it, but roughly to mention Article 14, 21, 23, 39, Article 39, when it comes to directive principles of state policy, talks about adequate means to livelihood, no abuse of health and work of men, laborers, both men and women at work. It talks about, Article 41 talks about public assistance in cases of employment, old age, sickness and disablement. Article 42 talk about just and human conditions of work and maternity relief. Article 43, it talks about living wage, conditions of work, ensuring decent standards of life. So we do have very strong constitutional premise to argue for very strong statutory regime for the protection of workers. So being understood that the labor law paradigm originate from constitutional provisions are very strong. The question is whether statutory regime is fundamentally capable of ensuring the constitutional promises to laborers in the country. When we look at our industrial laws that exist today, since the Industrial Relations Code 2020 hasn't been implemented yet, the law that exists today comes under three statutes. One is the Trade Unions Act, second is Industrial Disputes Act, third is Industry Employment Standing Orders Act. And these three legislations have very specific history, very specific rights history. It all originated from in fact, all of these legislations are colonial legislation, but it's all right-based legislation because it originated on the basis of lived realities of the people, and it originated through social movements. There is a lot of historicity for implementation of these rights when we look at the labor history. So what we need to understand is the current labor regime ensures rights in tune with the constitutional provisions. But when we look at today's labor reforms, the question is whether there is any reductionism from constitutional perspective towards labor rights as it stands now under the Industrial Relations Code. And whether this reductionism is for the benefit of the people or for the benefit of the other players in the market, and whether it's a reflection of neoliberal contribution, and whether it results in inevitable consequence of succumbing welfareism of the people to the market growth. So these are the relevant questions that comes to our minds. Basically, whether these labor reforms intend to ensure more rights to the labor, because we all know that a legislative change happens only when there is a need of a time to interpret a right or change a right to suit to the people, to suit to the development of people's lives. So legislative change is demand of the time, but a mere legislative change will not ensure welfare of the people. So in order to ensure welfare of the people, it should suit to the need of the people. And when we talk about labor rights, laborers are the backbone of Indian economy. Laborers are the backbone of any small unit that exists in the society. Take the case of a family. In a family, the economic independence, economic sufficiency of a family depends on the income that comes to the family. And when we talk about income of the family, the income of the family depends on the wages, the employment. So employment rights relating to wages, employment rights relating to right to work or security of tenure, all of this become very important in daily lives. So any change in legislative framework should ensure better conditions of work, better living standards, better income for the laborers of the country. So the question that comes into comes for inquiry is whether there is any lowering down of standards of constitutional rights coupled with flexible or regressive statutory rights regime in the current labor courts, whether that would curtail the powers of judiciary to interpret rights in a broad manner. Definitely, these are important questions to look at, because we all know that today there are a lot of, this is also a period of critical legal studies. And in critical legal studies, we always argue for decolonization of constitutional law and constitutional jurisprudence. And when we talk about decolonization of constitutional law and complementary legal frameworks, we should not lose sight of rights-based approach. We should not lose sight of social justice framework. The moment we leave out the powers to the power of the sovereign to the hands of the hegemonic players or players in the market, then we are leaving out the status, evading the responsibility of welfareism. And we know that our constitution fundamentally believes in welfare approach. So the question is whether there is new colonialism that is getting penetrated through new legislative frameworks to the labor market, to the labor paradigm. To come back to our topic again, labor reforms, as I mentioned, labor reforms is not something new. It was always there from the beginning of. We all know that the labor rights became a matter of debate from First International onwards, after Marx and Engels' intervention. So from First International onwards, there was always a demand for labor reforms. And labor reforms was to elevate the status of the worker, it was in order to balance the powers between the employer and the worker. So while we look at this history of labor reforms in India in particular, we had several labor documents that talked about labor reforms. Firstly, I would like to take your attention to Royal Commission on Labor, which came in 1929. So Royal Commission on Labor 1929, which is popularly known as Whitley Commission on Labor, this report basically emphasized on generous and justiciable policy for labor, because the understanding was only if there is increasing the potential of labor, there would be more production of the shop floor. So in order to increase the potential of labor, it's so important that the workers should be given more benefits. So Whitley Commission on Labor, talking on justiciable provisions for the upliftment of laborers. It's a very important report as far as the labor literature in India is concerned, because the colonial government looking into the working conditions of plantation labor in India and suggesting certain recommendations and recommending certain laws, policies to come in, especially in respect of reducing the working hours, and also talking about regulation of working conditions, and talking about social security provisions and certain other welfare provisions under different legislations. So this is first report, Whitley Commission report 1929 is the first report, which argued for labor reforms to elevate the status of workmen and to talk about the prosperity of industry in India. So when you read this report, you get an understanding that while Whitley Commission was studying on Indian labor, the intention was to balance the lives of the laborers vis-a-vis the prosperity of the industry. It was well understood to the commission members that the prosperity of the industry cannot be imagined without workers being able to produce. So efficient production, the workers' efficiency contributed production of the production in the industry. That understanding led to arguing for more reforms to elevate the status of workmen. So then again, when we look at history, the another document that argued for labor reforms post-independence was First National Commission on Labor, 1969. First National Commission report, 1969 report. This is definitely a post-independence, a first labor policy document that came after independence. And it was Justice Gajendra Gadkar, one of the doyens of labor jurisprudence in India, who headed this commission. And it's a very fabulous report which sort of detailed down the objectives and intentions of all labor legislations in India. And it also recommends certain suggestions in order to strengthen the labor rights of the workers in India. And more importantly, the focus in the entire report is on industrial harmony. And more interestingly, again, it talks about the coexistence of employers and workers in a democratic country. So democracy, internal democracy and external democracy in an industry establishment, synchronizing the interests of employers and workmen is being indicated as one of the main objectives of labor policy in this report. And it says that state policies must be fair to the employees and consistent with the good of the community. These are the wordings from the report itself. It says state's policy must be fair to the employee and consistent with the good of the community. So this comes from the constitution. The good of the community, the welfare of the people is the basic that the constitution talk about, the basic rights that constitution talk about. So when 1969 report argued for, demanded for certain improvements in law, certain improvements in labor rights, it was also to uplift the workmen for better benefits. And there were certain areas, gray areas within the labor law paradigm, especially relating to wage policy, contract workers' rights, social security provisions for unorganized workers, etc., where the First National Commission on Labor recommended certain suggestions, certain alterations. And so as I mentioned, First National Commission on Labor becomes the first important document post-independent India that talked for labor reforms. But it was also in order to strengthen the status of the workmen. We had Second National Commission on Labor in 2002. Second National Commission on Labor 2002 was headed by Mr. Rakesh Verma, and there were two important tasks assigned to Second National Commission on Labor. One of them was to suggest a rationalization of existing laws relating to labor in the organized sector. The other was to think about or suggest an umbrella legislation for the benefit of the unorganized sector, workers in the unorganized sector. This argument, that is rationalization of existing laws relating to labor in the organized sector. This is one of the arguments of the current labor reforms. However, the what does mean rationalization laws? It's on making laws more consistent with the context, more consistent with either, less cumbersome, simple, and more transparent. So even Second National Commission on Labor talked about labor reforms, talked about rationalization of existing laws. It was nothing to reduce the rights of the workmen under the current legislative framework, but to just to make the process, the procedure more simpler, less cumbersome, transparent, for more women to access and more women to use it for benefit. If they were to reduce the rights of the work.
Sophie ma'am, sorry to interrupt, ma'am. Sophie ma'am, sorry to interrupt, ma'am. Your voice is breaking, ma'am. Your voice is breaking.
Yeah. Yes.
Ma'am, your voice was breaking, ma'am. Sophie ma'am, sorry to interrupt, ma'am. Your voice
Am I
is
better
breaking, ma'am.
now?
Your voice is breaking, ma'am. No, ma'am. Still it's
Am I better now?
still it's breaking, ma'am. Still it's breaking. Now we can listen to you, ma'am. But still it's breaking.
Am I better now?
I think now it is clear. No, ma'am. Still it's yeah. Now it's clear. Now it's clear, ma'am. You can continue, ma'am. Now we can listen to you, ma'am. But still it's breaking.
Is it clear now? Okay.
I think now it is. Yes, ma'am.
Breaking continuously or just that?
You can continue, ma'am.
Was it breaking continuously?
For last
Should I
2 minutes.
restart
For
from
last
there?
2 minutes. For the last 2 minutes, it was breaking, ma'am. The rest of the time, it was okay.
Yeah. So, okay. So I think we were discussing about Second National Commission on Labor 2002 and Second National Commission on Labor 2002, as I mentioned. Though it talks about rationalization of existing laws relating to labor in India, it never talked about reduction of existing labor rights. It only talked about making the law more consistent with each other because we have on labor rights. So it just talked about making the procedure more accessible, more smoother, more simpler for the workers. It was nothing about reducing the labor rights spectrum ensured to the worker from the statutory regime that exists. Lastly, I would also like to draw your attention to more recent labor reforms suggested by a commission appointed by the government in 2007. It is Arjun Singh Gupta's commission. The commission is called CEUS, National Commission on Enterprises for Unorganized Sector. It was established in 2007, and the mandate of the commission was to suggest labor policies for the benefit of the unorganized sector. Even Arjun Singh Gupta's reports, so very valuable reports. I think it didn't come to domain in a but at least there were 11 reports that came from Arjun Singh Gupta's commission from 2007 to 2009. very rich culture. And even when Sangupta's report argued for reform, it was nothing about reduce the rights of the workmen. It was nothing, no reductionism that it was argued for. It is always about more inclusive approach that the labor law requires or the legislative framework requires with respect to, with special reference to the conditions of workers in India. So what we need to, I mentioned all of this history of labor reforms in India only to make you understand that none of these policy documents, none of these documents argued for labor reforms talked about a regressive statutory framework. It was always argued for a none of these documents argued for labor reforms talked about a regressive statutory framework. It was always argued for a
Hello, Sophie, ma'am. Hello, ma'am.
yes.
Ma'am, your voice and video is breaking, ma'am. Your voice and video both are breaking.
Okay, what I can do is I can switch off my video. Maybe you know.
Okay, ma'am. Since you are presenting PPTs going on, right? It is okay, ma'am. For the time being, just you can turn off your camera. You can speak.
Yeah, I will do that. Just a minute.
Sure, ma'am. Sure, ma'am. PPTs going on, right? It is okay, ma'am. For the time being, just you can turn off your camera. You can speak.
Yeah, I will do that. Just a minute.
Sure, ma'am. Sure, ma'am.
Okay, let me see whether this would work. Okay, so we were here. Now, since we have understood what's the constitutional basis of labor rights in India and what is the context of labor reforms in India so far, it's also important to look at, as I mentioned in the beginning, our endeavor is not to look at the entire labor reforms introduced by the government in the last 2 years. Our endeavor is only to look at the industrial relations code because our time won't be enough to look at the entire labor codes that have come in. Those are coming. So yeah, for the discussion, for the sake of discussion today, we are confining to industrial relations code 2020. So in the context of what we heard so far in relation to labor reforms, when Industrial Relations Code 2020 was introduced in the Parliament, the whole argument was the Indian labor law on industrial relations is very rigid. And this argument of rigidity of Indian labor law is nothing very new again. And where is it coming from? So it's very important to know where is this argument of rigidity of Indian labor law coming from. It has its own history, which actually became more visible and more argumentative in 1991, especially after post-Washington Consensus, after our LPG liberalization policy came. So in the liberalization debates in 1991, the question whether India should agree to LPG policies, when those debates were happening, one of the demands put forward by organizations, Washington organizations, were three organizations mainly: IMF, US Treasury, and WTO. So one of the arguments put forward by the Washington organizations were India has a very rigid labor law regime, which need to be flexibilized in order to promote more investment and availability of more labor. So that is the argument. So the rigidity of labor law regime, it actually comes not from within, it came actually from outside. So it was post-Washington Consensus, there was a rigor to change our labor law framework, change our rights-based legal framework. And there was all discussion on how to flexibilize labor law regime. And when I talk about flexibilizing labor law regime or making Indian labor more flexible, what I meant to say is taking away safeguards for the worker and giving more flexibility to the employer to go ahead with their activities, their business in India. So unless labor procedure is flexibilized, the employer cannot go ahead with procedures or cannot go ahead with their business at their will. Because labor standards, as we all know, it puts a lot of embargoes, lot of obligations on the employer to go ahead with their activities, especially if an employer wants to start a factory, wants to start a industry establishment. There are many procedures that he has to go through, and he has many obligations charted out, detailed out under the legislation. So it was the attempt of the employers' lobby was always to ask for flexibilizing labor, regulations, and reduce their burdens, reduce their obligations under the statutory framework. So this flexibilizing labor, deunionizing labor, it was a demand that started with 1991. And by way of flexibilizing labor, what they intended at was increasing informalization of labor and lower the wages of the workers. And when we talk about informalizing labor, informalizing labor means leaving the worker out of formal rights or leaving the work out of the spectrum of formal rights. And what are the formal rights? The formal rights are generally right to wages, right to security of tenure, right to social security. So by way of flexibilizing labor, what the employer achieves is more and more evasion of obligation towards workmen. They don't need to, the employer can evade obligation to give wages to the workmen. They can evade obligation to give security of tenure to the workmen. They can evade social security benefits to the workmen. So basically, this is the flexibility that they demanded for. The characteristics of flexible labor is initiated to be lower wages and deunionization, that is informalization of formal workforce in India. When you look at today's Industry Relations Code, when you critically analyze today's Industry Relations Code, which has come in 2020, it talks about many things. It talks about, it has tried to amalgamate three enactments together: the Trade Unions Act, Industry Disputes Act, and Industry Employment Standing Orders Act together. When you look at this code very seriously, in between the lines, what you understand is there are erosion of certain rights that has been suggested, that has come in, that has crept into the legislation. So there is erosion of right to strike and security of tenure. There is more and more aggravation of the phenomenon of fire. And there is certain flouting of procedure under the legislation. That means there is more flexibility to the employer to do away with certain procedure. Though the enactment, when the Industrial Relations Code was enacted, the main contention was this reform is suggested in order to have more inclusionary approach by including unorganized sector into its ambit. But when you look at the actual enactment, we don't see any provision that talks about inclusion of unorganized sector or suggesting dispute settlement mechanism or industrial rights for the workers in the unorganized sector. So it's a lip exercise for inclusion of unorganized sector that has been provided in the objective statement of reasons and objectives of the code. And it gives magnanimous flexibility to the employer, which in turn weakens the rights of the industrial worker and their status in future. And to be very specific about what are the issues that arises from the specific provisions of the Act. I have categorized the issues into 5, and one is definitely when you look at jurisdictional issues, there are certain restrictions and ambiguities very clear. When I talk about jurisdictional issues, because jurisdiction of a particular statute is always decided by the breadth and width of the definition clause. So jurisdictional issues, when you look at jurisdictional issues emerging from the definitional clauses, there are certain ambiguities and restrictions. And restraint is mainly in relation to the definition of industry. We know that there is a very wide jurisprudence relating to definition of industry. And when it comes to industrial relations code, it says industry, the definition is quite big, quite large. I'm not reading it in entirety. But towards the end of the definition of industry, it says the central government has the power to decide. Okay, the central government has the power to decide which of the activity would come under the definition of industry. So earlier, the definition that exists under 2P of the Industrial Disputes Act was very clear. It was a very inclusive definition. Here, it has been defined very elaborately, but at the same time giving wider power to the central government to decide what activity would come within this. So this actually gives a very overarching power to the central government to decide what kind of establishment would come under the definition of industry. So this is a wider power provision. And then we also see certain ambiguities in the definition of worker and employee, because in the earlier enactment, there was only definition of worker. Now we see the definition of employee coming in, but not clear about what is the purpose of including this definition. And when you read worker and employee definitions together, you find that there is overlap. There is overlap between two definitions. But at the same time, there is nowhere that employee definition being talked about except under one instance, the entire code. So bringing this definition, one more category within the ambit of the industrial relations law, brings more ambiguities rather than solving the issues. Because our entire argument was the new labor reforms is to rationalize or rationalize the existing laws. If the objective is to rationalize the existing laws, the importance should be given to avoid ambiguities by bringing in more and more redundant provisions. So we see that employee worker two definition doesn't serve any purpose. It creates more ambiguity, and definitely in future this is going to open up a possibility for many more litigation. And as I mentioned, the second problem that I identified with the industrial relations code is definitely exclusion of unorganized sector. So unorganized sector is still oblivious to the code. You don't see any provision under the industrial relations code where it talks about rights, any industrial rights for the workmen in the unorganized sector. So it remains as a lip sympathy in the or lip exercise in the statement of reasons and objects of the code. There is no active intention to include unorganized sector in the purview of industrial relations code. I emphasize on inclusion of unorganized sector under the labor law, for the reason that in India, the reality is 93% of our population or workforce is in unorganized sector. Only 7% is in organized sector, that too according to 2008 data. So now more and more, because the policy is to contractualize the workforce, more and more contractualization is happening in the formal labor market. So we assume that now the number of unorganized sector would have gone high from 93%. So it's so important that an industrial relations law for unorganized sector exists, because more and more workforce, majority of workforce in India is out of the ambit of industrial relations law. This becomes very important. This coverage of unorganized sector or inclusion of unorganized sector becomes more important because more underprivileged population, marginalized population, SC, ST, OBC, Muslim population are working in the unorganized sector. As I mentioned, Arjun Sengupta's commission report clearly details out the statistics of workforce vis-a-vis social location of workers in the unorganized sector. The report states that around 83% of SC/ST workforce is in unorganized sector, and majority of Muslim marginalized people are in the unorganized sector. So there is a clear data as to how marginalized people, because of their lack of assets, lack of mobility, get pushed to unorganized sector where there are no rights available. So it's so important from a welfare state approach to include them in the legislative ambit, and that's not attempted in this law. Thirdly, I find that there is erosion of right to organize and collective bargaining under the law. When I talk about erosion of right to organize, I say this because for a long time, the demand of the trade unions and employees association, workers association was there should be protection against dismissal for union activity. And though we do have a provision for protection, it is only for union executives, protected workmen. For non-union officials, for union members, normal members of a union, they don't have any protection against dismissal. So it's so important that in order to have proper unionization, because unionization is the means to achieve labor rights in an establishment. So in order to have more organization, more mobilization between the workers, it's so important that right to dismissal, right against dismissal for union activities ensure, which is not the case in the Industrial Relations Code. And again, today when we look at Industrial Relations Code, the negotiation, the matters of negotiations are completely left out for the central government or state government to decide. Early it was not the case. Early, if there is a negotiating union in the establishment, the matters, any matter could be taken up by the negotiating union with the employer. There was full freedom for the negotiating union to take up the matters relating to welfare of the workers for the employer. Now that has been left to be regulated by the government. And when the regulation comes, it would definitely clamp down the flexibility or the freedom of negotiating union. Fourthly, I take upon erosion of right to strike. Though right to strike is mentioned under the Industrial Relations Code, it actually de-emphasizes the right in a way. How do they do it? How do industrial relations law do it? It has expanded the definition of strike to include casual leave. For example, if majority of workers on a particular day go on casual leave, then that casual leave becomes a strike. So earlier, the strike was refusal to work on a particular day. definition was simple. Now the law says if the majority of workforce go on a strike, then that would amount to strike. So they are expanding. That's an expansion of definition of strike. And what is strike understood to be? Strike is understood to be a weapon in the hands of the workman uh, to force the employer to come for bargaining, collective bargaining. So strike is concerted refusal to work. Here, when the workers decide to go on a leave, on a casual leave, if the majority of the workers go on a leave, that would be termed as a strike. So it's very regressive measure in its ambit, in its objective. And then secondly, when it talks about right to strike, earlier we all know that in public utility service, there was a mandatory notice provision, but in other services, other industry establishments, there was no requirement for giving mandatory notice. So now, under the Industrial Relations Code, in any establishment, be it public or private, every establishment need to give a mandatory notice before going on strike. So that also takes away the flexibility of the workmen to go on a strike on multifarious issues, because sometimes it so happens that there is a verbal abuse or caste abuse of a worker on the shop floor. The workers immediately resort to concerted action like strike or demonstration. Now that's not possible. In any case, the workers have to give a strike notice, then wait for the compulsory days to get over for going ahead with strike. And enhancement in fines. That is another provision that we see under the Industrial Relations Code. So, in case the worker engage in illegal strike, the fines have been increased to 10,000 rupees. So, there is enhancement in fines in the case of illegal strike, but in the case of illegal lockout for the employer, there's no enhancement in punishment. Fifthly, I also recognize certain new flexibilities and exemptions introduced for the employer for easy for making their business or running their business in a smoother way. There is a new category of employees introduced under the law, which is called fixed-term employees. And fixed-term employees are different from regular employees and contract employees. Fixed-term employees are employed for a fixed term. They do have rights, benefits equivalent to regular workmen. Benefits. It's an economic benefits equivalent to regular workmen, but they do not have right to security of tenure. That means that on the expiry of their fixed term contract, their employment automatically expires. They cannot raise a dispute. It's not a retrenchment. They cannot raise a dispute. So termination is automatic on expiry of contract. And this fixed term employment, it doesn't talk about how many years a workman can be kept on contract. It also happens that in certain establishments, they do keep workmen on contract for 30 years. They keep extending the contract for contract every year or every 3 years, and keep the workmen on contract for 20 years. That actually gives the employer more flexibility to evade social security provisions, because their employment is getting interrupted or getting terminated every fixed term of either 1 year or 3 years. So after every 3 years, the workman is taken as a new employee, not as a continuing employee. So they can evade a lot of social security provisions, because we know that in order to get gratuity, we need to put in continuous service of 5 years. So social security benefits, in order to get benefits, there are certain continuity that becomes part and parcel of the legislative criteria. So here, fixed term employment helps the employer to evade obligations under other legislations. They can keep the employee and terminate the employee at their whims and fancy. So here, law relating to notice of change. That's another flexibility given to the employer under Section 40D of the Code. The mandatory notice that needs to be given to the workers can be overridden by the employer by applying to the appropriate. That means appropriate government can override mandatory notice by way of its own order. This actually gives a wider power to the appropriate government for the reason that there is no guideline that being given under this flexibility. So generally under law, as it exists under the Industrial Dispute Act, we see that under Section 9A, the employer has to give mandatory notice to the workman in case there is a change in conditions of service. So this mandatory notice period gives the time for preparation to the workman if it prejudicially affects their rights. And here in this case, the appropriate government can need not give mandatory notice for its own reason. If the reason is not to be made public, so it's a very wider power to the appropriate government.
ഹലോ മാഡം, ഹലോ.
Yes.
സജി മാത്യു ആണ്. അത് ചെറിയ വോയിസ് ബ്രേക്കിംഗ് ഉണ്ടല്ലോ ചെറുതായിട്ട്.
Hi, Suji. So probably it may be that connectivity issue. I really don't know.
സജി മാത്യു ആണ്. അത് ചെറിയ വോയിസ് ബ്രേക്കിംഗ് ഉണ്ടല്ലോ ചെറുതായിട്ട്.
Is it continuously breaking?
No, ma'am. It's intermittently. Intermittently, it is getting break. Now it's clear, I think.
Okay, I'll just keep the laptop a little more close. Probably I'll see how to. It's a bad day for the net, probably.
Now it's clear. Okay, ma'am. Now it's clear. Now we can listen to you clearly.
Okay. As I mentioned, there are certain exemptions as well given to the employers under the Industrial Relations Code. It basically gives exemption to the industry establishment. So the government can exempt certain industry establishments from the applicability of this provision. This is not there. This was not there under the early industrial relations law. It's a new flexibility. And the law also doesn't specify what does it mean by public interest, though it says that on the ground of public interest, the appropriate government can exempt the industry establishment. It doesn't particularly explain what is public interest. We all know the enormous litigations those have played out under the Acquisition Law, Land Acquisition Act on the ground of public interest. And the interpretation of public interest has been watered down so much that it is anything that feels to the government as public or public purpose. So here, this is again a watering down of the obligation of the employer to adhere to the provisions under the Industrial Relations Law. Next is flexibilities introduced the right to security of tenure. As I mentioned, the backbone of industrial relations law is the provisions relating to security of tenure. It's security of tenure that ensures employment for workmen for a particular period. And now we see that the provisions relating to retrenchment, especially being intervened with. When it comes to retrenchment compensation, the law today says, Industrial Relations Law Code says, the compensation, retrenchment compensation can be decided by the appropriate government. So it can be notified by the appropriate government. Earlier, the law was very clear. Retrenchment compensation has to be 15 days average wage for every continuous year service. Now it says either 15 days average pay or average pay of such days as may be notified by the government. So here as well, when security of tenure is abridged, retrenchment compensation need to be provided, that is completely left to the decision of, that's a discretion for the government to get in over there. Likewise, I'm not getting into the details of next provisions, but definitely that this increased threshold for application of standing orders. And we see that the threshold has been increased from 100 workmen to 300 workmen. And there is also exemption given to industry establishment from the application of standing order. And that exemption is very wide and arbitrary because it doesn't specify any ground or guidelines as to on what condition or on what ground the appropriate government can exempt industry establishment from applicability of standing order. So such arbitrary, wider, discretionary power vests with the appropriate government always results in arbitrary exercise of power. Time again and again, Supreme Court has intervened in earlier cases under the industrial law jurisprudence relating to discretionary powers vested with the appropriate government, and has stated that the appropriate government shouldn't have discretionary powers without wider guidelines because it affects the basic labor rights of the workman. So here as well, we see that these Supreme Court canons are not being adhered to or addressed in the new law. When you look at from the angle of rights-based approach, there is definitely substantial reading down of labor rights. To be mentioned in few sentences, right to strike, right to organize, right to collective bargaining, right to security of tenure, right to have safeguards regarding conditions of employment, terms of employment. All of these rights have been watered down in one way or the other. And these are the points that we need to deliberate upon and think about, because the only possibility now, if this enactment comes into picture, implementation is to go for amendments. So we need to keep this in mind and then argue for amending the law, complying the international labor standards. All of these points that I mentioned today resides in violation of international labor rights, because right to strike and collective bargaining is a unconditional right coming from Convention number 87 and 98 of the International Labor Organization, which is one of the obligation of India as a founding member of ILO. So it's a mandatory convention to oblige. So our law would result in violation of those conventions, and definitely the other watering down of provisions would definitely result in violation of international labor rights. So we do need to think upon these provisions in detail and think about possible reforms or possible amendments around these rights. The point is, whenever we visit a framework of labor law, which actually affects the basic right of a living individual in a state, it has to be more inclusive. It has to be through a right-based approach. It has to be for more improvement. It has to ensure improvement in the living standard of the worker. It shouldn't be regressive. It shouldn't be retrogressive. It shouldn't diminish or deteriorate the standard of living of an individual citizen of the country. So revisiting legislative framework is also always to elevate the status of a citizen of the nation. Another point that I want to stress here is of late post-modern feminism debates that happened in labor rights in India, labor rights internationally. One of the demands always had been to recognize the value of women labor. Even when labor reforms were suggested, debated in India, one of the arguments of the feminist organizations were to acknowledge, value women's labor. And that was always, that has always come in the form of debates around unpaid work. reproductive labor of women in professional space as well as personal space need to be respected, need to be valued through policy. That was always the debate, and that has also come in. I will conclude my entire conversation today, posing 4 questions majorly. This is actually questions for all of you to think whenever you come across anything relating to labor reforms or labor rights. Firstly, whether the labor law framework today can only be on the basis of class, because I put this question purposefully because today our labor law framework looks at worker as a category and employer as a category. At the same time, we talk about there are different set of workmen within the worker category. We already mentioned in workmen in unorganized sector and workmen in organized sector. So when we think about labor law framework, we need to cater to the needs of different set of workmen within the worker category. So workmen in the unorganized sector need to be focused upon in order to ensure dignity to majority of workforce individuals. So whether this monogamous or homogeneous focus on worker would help in order to ensure dignity to entire workforce in India. We need actually more in order to have an inclusive labor law framework. It's so important that unorganized sector workmen, specifically their demands, their rights, their living conditions and working conditions, specifically looked at against their social occasions and addressed upon. Secondly, the second question is whether these reforms constitute any dilution to the existing labor rights under the legislation. I think this is the primary question we need to ask, whether these legislations are giving better rights or taking away any rights of the worker. If it's taking away any rights that exist today under the early legislation, we need to think about whether it's ideal to go ahead with. Thirdly, if it's consolidation of the existing legislation, understanding the fact that these labor reforms do not address the needs of requirements of workers in unorganized sector, whether we require a 5th code in order to address the demands of workers in the unorganized sector. So apart from this 4 codes, do we need a 5th code at all? Lastly, the 4th question, what is the possible legislative and judicial strategy to strengthen rights-based approach with the courts today? We can do this. We can answer to this question only if we understand the ambiguities in the present law and think about a better strategy to present the ambiguities before the court and get an interpretation using the tenets of classical labor jurisprudence from the higher judiciary that already exists. So I end my conversation with this 4th question. I'm open to conversation. Thank you so much. Thank you so much. Patient listening.
Thank you, ma'am. Thank you for your valuable words. So, students, now it's your turn. If you want to have any, want to ask something, you can ask from ma'am. If you are having any doubts to clarify, you can clear. Thank you for your valuable words. So, students, now it's your turn. If you want to have any, want to ask something, you can ask from ma'am. If you are having any doubts to clarify, you can clear. So,
questions need not be so pointed. It can be very general. It can be very basic. It's just a conversation. I know that we haven't had many deliberations in public domain relating to labor reforms in detail, in depth. So especially, at the outset, I have to also say that labor law is very connected with the political economy, the economy of the country. But we always don't get the opportunity to read labor law service or labor law against the political economy of the nation. So it's so important to read everyday economic dynamics of economics and read it against the policy change that happens in labor law paradigm. What I meant to say is you can ask even basic questions, anything that comes to your mind. That happens in labor law paradigm. What I meant to say is you can ask even basic questions.
Okay, anyways, thank you, ma'am. Thank you for your valuable words. So next, I would like to invite Ms. Zora for a word of thanks. Zora, ma'am.
Sophie, ma'am, I got a question. It is general in nature. The thing is,
Very.
the lecture labor law amendments, whether it is of help to the so-called exploited laborers.
Yeah.
Recent developments.
Yeah, very thanks for this question. Thank you very much for this question. I think one of my attempts in the presentation was to, show you or prove you how industrial relations code in particular um, proves that the provisions itself proves deterioration in rights of the existing rights of the workers. So when we look at the enactments in particular, even when we look at code on wages, we don't see clarity on any of the concepts. Code on wages particularly, it talks about national minimum wage. It doesn't talk about calculation methodology relating to wage. So a lot of ambiguities. There is no clarity on how are they going to ensure national minimum wage. It's a lot of statements being provided as provisions without legislative root. Under the industrial relations law, since industrial labor rights are more clear in apparatus, when it comes to wages depends on calculations, methodologies, etc. So there is a bit of arithmetical work, consumer price index, all of that is involved. But when it comes to Industrial Disputes Act, it's more clear and non-ambiguous in relation to rights. But when you look at Industrial Relations Code, that's why there is reduction in substantial rights. So when we look at right to organize and collective bargaining, one of the main objectives of industrial relations law is to ensure right to collective bargaining and right to organize for industry development. That's what industrial relations code needs to be checked against. The right to strike is being watered down. Right to negotiation being watered down. Right to unionization being watered down. So, there is substantial reduction in rights. Standing orders, as I said, it's a massive watering down of standing orders. There is increase in threshold level. There is wider power given to the appropriate government to exempt this justice establishment from applicability of industrial relations law. So all of them indicates what is the main focus of legislative exercise. It is more to ensure rights to the citizens, ordinary common men. But here we feel that if the ordinary citizens' rights being taken away and more focus is towards benefiting the employer, then the welfarist approach that we talk about that comes from the constitution is not adhered to, is not complied with. So that's where I think we need to critically look at these codes and then think about or advocating for more and more innovative amendments and innovative legislative policies to protect our workmen. Otherwise, we will become exploitative workforce, as it has already become. We see that workforce is very much exploited even in formal institutions, including academic institutions and in other institutions as well. Contract labor is increasing day by day without any security or tenure, and they become an object, shatters at the hands of the employers. So that needs to be arrested, that needs to be prevented. And that's the aim of labor law. Labor law was actually carved out of common law in order to make sure that the workers are protected, the laborers are protected. And that's the aim of labor law. Labor law was actually carved out of common law in order to make sure that the workers are protected with the labor reforms.
Thank you. Any other students? So, any other student? Thank you. Any other students? Okay, next I would like to invite Zora for vote of thanks.
Thank you, Gina ma'am. Good morning all. I consider it as an honor to propose the vote of thanks for this webinar. At the very outset, I'd like to express a heartfelt indebtedness and gratitude to Dr. Sophie KJ, who is an assistant professor of law at National Law University, Delhi. Ma'am has spared her valuable time with us here today. Ma'am, you have definitely thrown light on the history, objectives of the labor reforms, and the issues that are related to the Industrial Relations Code. Ma'am, you have taken tremendous efforts for your talk on this evolving subject. And like you said, ma'am, it is always a question whether it is ideal to go ahead with a legislation that takes away the rights of the people to whom it is supposed to be addressed to. Thank you, ma'am. Next, I would like to thank our principal, Dr. Rani George. Ma'am has always shown her constant support in organizing webinars. Thank you, Rani ma'am. I would like to acknowledge the management of CSI ILS for arranging this webinar. On behalf of the institution, I would also like to appreciate the faculties who have put their sincere efforts. Last but not the least, thank you to each one of our students who have joined here with us. Thank you all. I would also like to appreciate the faculties who have put their sincere efforts. Last
Thank
but
you.
not the least,
Thank you very much. Thank you, everyone.
one of our students who have
We
joined
meet at
here
some
with
other
us.
occasion.
Thank you all.
All of you stay safe. Take care.
Thank you.
Thank you, ma'am. Thank you, ma'am.
Thank you. We meet at some other occasion.
Thank you, ma'am. Thank you, ma'am.
Stay safe. Okay. Okay. Thank you. I'm leaving the meeting. Thank you very much.
Thank you, Sophie.
Thank you. Thank you,
Thank you,
Ram.
ma'am. Thank you, ma'am.
Thank you, Gina. Thank you.
Thank you, ma'am. Thank you, ma'am.
Okay. Okay. Thank you.
Mhm.
I'm leaving the meeting. Thank you very much.
Thank you, Sophie.
Thank you. Thank you, Ram. Thank you, Gina. Thank you.
Host പോയോ host?
Chaksara.
ഉണ്ട് മാം, ഇവിടെ ഉണ്ട് മാം. യെസ്, ഹോസ്റ്റ് ഉണ്ട്. ഉണ്ട്
Host പോയോ host?
Chaksara.
ഉണ്ട് മാം, ഇവിടെ ഉണ്ട് മാം. യെസ്, ഹോസ്റ്റ് ഉണ്ട്. ഉണ്ട്.